Hi, my name is Robert Chelle with Chelle Law, and I'm an attorney that assists physicians with employment contract and independent contractor agreement issues. Today I'm going to talk about physician moonlighting rules. So, what are some standard things that are placed in employment contracts that can prohibit the physician from working while they are employed? So, first thing to identify what type of contract you're on. Are you an employee with an employment agreement? Or perhaps you're an independent contractor working under an independent contractor agreement. There will usually be some kind of restrictions on where you can work during the term of the contract, which I'll discuss in a second. If you have an independent contractor agreement, there should be no restrictions on where you can practice. Obviously, you have to, show up to whatever the job is and not have, two things going simultaneously. But there should be no exclusivity language in an independent contractor agreement. That kind of goes against what an independent contractor agreement is meant for. All right, so if you do have an employment agreement, what will it stop you from doing? Well, most employment agreements will have some kind of section called exclusivity or outside activities, or something that simply says you cannot practice medicine anywhere else during the term of the contract without our written approval. This is not an uncommon thing. In fact, it's in nearly every single employment contract that I review. And it's simple. If you're working full-time, or even part-time as an employee somewhere else, they want to dictate when and where you work. And so they certainly are within their rights to say, we don't want you working, X, but okay, maybe we're okay with you working somewhere else. Some considerations. One, a non-compete not only could apply after the contract ends, but many times it'll say it applies during the term of the agreement. So let me give you an example. Maybe you're, primary care physician working in one office, and then your non-compete will say you can't work either during the term or after within a 10-mile radius of the clinic. And so if you were to approach the employer and say, I have an urgent care opportunity on the weekends, 15 miles away from the clinic, is this something that I would be allowed to do? Well, the employer would be, much more likely to say, yeah, that's no problem, versus you have a 10-mile non-compete, you come to them and say, I want to work on the weekends in a primary care office a mile away. It's very likely they're going to say no to that. Some of the most common physician specialties where they want to have the opportunity to do other types of work would be radiologists who want to do some telerad on the side, maybe some people in mental health who want to do some telepsych on the side, or those who do shift work. So if you're a hospitalist, maybe you're in the emergency department, maybe you're on 7 on, 7 off or something like that, and you'd like to do a couple shifts on your off week, that would be another time where you would want them to give you written approval in order to work elsewhere. And once again, keeping in mind, the farther away from where you're working, the more likely it is that they're going to give approval. Although it honestly makes no sense that a hospital would care where a hospitalist provides care at. It's not like a patient is coming to a hospital specifically for a hospitalist. There's really no competition that could be justified, in my opinion. However, you're still going to see the outside activity prohibition in any kind of employment agreement for a hospitalist or emergency medicine. Last thing, malpractice coverage. Your malpractice policy is specific to the employer. So if you're working as a full-time employee somewhere, you're going to need an additional malpractice policy when you're working elsewhere. If you are working any kind of outside job, it's extremely likely that they are going to provide the malpractice for you, but there will also likely be language in your current employment contract that says you have to provide proof of coverage from any kind of outside employer, or if you're working as an independent contractor. So just keep in mind there may be some additional responsibilities that you have to do under your current contract if you're going to work elsewhere. All right, that's a little bit about physician moonlighting and some things to take into account. If you have any questions about outside activities, an employment agreement, or independent contractor agreement, feel free to contact my law firm at the information listed below in the description. And I appreciate you watching the video. All right, thanks. Take care.